now, especially with what we heard yesterday from the courts nullifying the primaries of the PDP?
Well, you know that the former deputy governor has been purportedly impeached. That is clear. You also know that he's in court challenging that impeachment. I don't think a decision has been made on that challenge. But for the decision of yesterday, delivered by the Honorable Justice Eko, I think it was pretty clear what the court said. A couple of delegates were aggrieved that they were unlawfully excluded in their own words from the list of delegates that were elected for the purpose of conducting the primaries to select the governorship candidate of the PDP in Edo State. Sequel to their grievance, they went to the Federal High Court, Abuja, to challenge them. And then, at the end of the day, Justice Eko's opinion, as he expressed clearly yesterday, was that there was evidence before him that about 300 and something of the delegates were unlawfully excluded. He went on to say that there was also evidence before him that the method in which the delegates were excluded was expressed by the fact that in their return sheet with which they were elected, only one man signed as chairman in about 300 something wards. Only one man signed as secretary in about 360 something wards. The judge wondered whether one man could have been in 369 wards or thereabouts at the same time. And then the judge went on to say that INEC was silent. As an observer, did not say anything, did not corroborate what happened. The judge also went on to say he looked at the case of the delegate and he looked at the case of the candidate and the political party. He preferred the case of the delegate, and to that extent, he held that the primary itself did not conform and comply with the guidelines of the PDP and the constitution of the PDP. To that extent, that non-compliance rendered, according to the judge, that primary is unacceptable and unlawful.
So
he didn't go to the extent of saying, I disqualified this man or I did not disqualify him, but the law, the implication of an opinion of the judge is very clear.
all right, where does this then leave the PDP? And this is another thing. Some politicians might begin to hang on to the fact that, well, there was no clear statement from the judge or the court saying this person is disqualified. And with that, they might want to, regardless, say this judgment holds no water or doesn't directly speak to this issue, which is what we see among politicians in this country most times. And some would expect that the judge and the court, in his own wisdom, would see it fit to be more direct with what it is saying so that everybody understands. That's on one side. On the other side, what does this then mean for the PDP? What options does the party in Edo State have?
Okay, let me start with the first one. Whether what the judge means is clear to the public. Don't forget that the plaintiffs in that matter had a set of reliefs which they set out and which they asked the court to grant them. We were not part of the case, so we may not know that until today when more details will come out. That if those reliefs included the nullification of the primary on account of non-compliance with the guidelines and constitution of the party or the electoral law, and the judge, as he said yesterday, agreed with them, then of course the primary itself is nullified, and a nullified primary cannot produce a candidate. So invariably, it will mean that as of today, the PDP in Edo State does not have a candidate for the governorship election for 2024. This will be the legal realism, regardless of the words used by the judge. The clear meaning of the nullification of the primary will mean the party whose primary was nullified will have no candidate for that election unless, of course, they take further steps by way of appellate proceedings and they are able to halt the execution of that judgment or reverse same before the election itself.
All right. Now let's come to Rivers State, because we had a judgment from the appeal court. I'm sure you're very much aware of the political imbroglios in Rivers State, and at the moment there are those that are for and those that are for. I don't want to say against, because on everybody's side they seem to be right. But then we had this appeal court judgment that came, and you are a senior advocate, and with your wealth of knowledge within the legal space, what does the judgment from yesterday at the appeal court in Abuja, what does it mean for Rivers State and the Martin Amaewule himself as Speaker of the House at the time, and the lawmakers that are now said to be pro-Wike lawmakers?
Well, just let us say that the critical issue that was determined yesterday by the Court of Appeal was whether or not the State High Court had the jurisdiction to entertain the matter that was taken there by certain lawmakers and the order consequently made by that High Court regarding the fact that about 20-something lawmakers had resigned their membership of a political party that sponsored them and having decamped to another without complying with the provisions of Section 109 of the Constitution had their seats forfeited. Now, I start with the point of saying that I thought the Wike group or pro-lawmakers challenged the jurisdiction of the State High Court to hear that matter. The argument was that constitutionally, only the Federal High Court can hear that matter. And the Court of Appeal was invited to make a pronouncement on that challenge. Yesterday, the Court of Appeal made that pronouncement. The court said that under Section 272, subsection 3 of the Nigerian Constitution, it is only the Federal High Court that can determine such a matter. Subsection 3 is very clear. It said when it comes to the interpretation of whether a seat is vacant or not, with respect to House of Assembly, membership of the House of Assembly, the Federal High Court shall have jurisdiction to hear and determine that question. This is the correct interpretation given, in my view. The Court of Appeal settled that matter. But the big question would be, what is the next step?
Exactly. Because would the lawmakers now return to the Assembly?
Well, the thing is, the substantive matter that the Court of Appeal decided upon was a decision that stopped them from coming to the Assembly. Prior to them, there had been a matter in the Federal High Court, if I am correct. That matter had not finally decided whether the methodology of the campaign and the fact that they had decamped had brought about an end to their tenure. And I think, therefore, that there is still a question to be answered. The question would be, where are they today? In my view, they are left back in the House of Assembly. They are left back in the House of Assembly because the order of court that took them out has been nullified. When jurisdiction is succeeded, and when you successfully challenged jurisdiction. And the court said, no, you have no jurisdiction. The implication of the law is that you did nothing. You acted in vain. If you have no jurisdiction to try a matter and you made certain orders, and the appellate court says you have no jurisdiction, it goes back to zero, as if you did nothing. So my best interpretation would be to say those lawmakers will appear to remain in the House of Assembly.
All right.
The next question would be
Hold that thought, Doc. Hold that thought. We'll take a short commercial. We continue afterwards.
Nigeria Info.
Just stay on the line.
We'll be back. Port Harcourt City.
Introducing the
Good morning. I'm discussing with Dr. West Idahosa, a former federal lawmaker and a senior advocate of Nigeria. Doc, thank you for your patience and staying on the line for us.
Not a problem.
All right, and quickly, let me remind the listener that we are streaming live on Facebook at Nigeria Info 92.3 PH. We are also streaming live on YouTube at Nigeria Info PH, so you can watch and listen to us on any of those platforms. Use the WhatsApp number 0809 030 6416. I'm sure you have questions you would want my guests to respond to. Send those questions to us via messages, and hopefully you get the answers to them. We'll also open the phone lines in a matter of moments, but let me also put out this question to you who's listening. The idea that the judiciary is contributing largely to some of the leadership and political problems in the country has been going around for a while. Do you share in that thought? Let us know what you think. I would also get the opinion of my guest on that particular question, but before then, Doc, before the commercial, you were trying to explain the implication of the judgment that came out from the appeal court, and you were saying that it would mean that the lawmakers would have to return to the assembly. And now there are those who also have more questions, like there have been other matters in court by different bodies and the government inclusive, questioning the authenticity of these lawmakers still calling themselves lawmakers, looking at the fact that they have left their party. I think the PDP, even at the national level, had also gone to court to say that these people have left the party, so let their seats be vacated. Now that we have those situations, among many other issues that are in court, how does this particular judgment influence those other cases that we have in court? Does it influence them in any way?
No, I think this judgment has nothing to do with the other cases. What it has just settled is the question of venue. Because venue is very key, particularly when the venue is defined by the Constitution to be the place for the settlement of a particular dispute. I think the best thing to do is to go to that venue. There is no need to forum shop. Forum shopping is when you are looking for a court of favorable jurisdiction. If your case is solid like Olumo Rock, why not go to the right court and get it into it? And if you don't like what you are getting, you go on appeal. Now, I have told you the constitutional implication of going to the state high court to litigate whether or not the seat of an assembly member is vacant. I think the Court of Appeal was spot on. This is not politics, this is pure law.
Okay.
Now, what is the consequence on the membership themselves? It will mean they remain members unless there is another court order from the competent court, such as the Federal High Court, also placing an embargo on them from continuing to serve as members. If there is none, then it will mean that the main issue to be determined now will be to go back to the question of whether or not they are entitled to remain in the House. This is where there is a bit of confusion, and we will require strong judicial statesmanship or judicial activism. The confusion is based on the fact that among those who are said to have resigned from the party that sponsored them to the House of Assembly is the Speaker himself. The Speaker in court is said to have resigned, and under Section 109 of the Constitution, it is the Speaker who should determine whether or not there should be a vacation of a seat on account of the campaign from one party to another without meeting the requirements of the Constitution. So the question is, when the Speaker is one of those who purportedly decamped, will he make that determination? Will he not be a judge in his own matter? Will he, having moved with other members, declare their own seat, including his own vacant? I doubt it. And this is where the law of self-preservation comes to play. He would like to preserve his interests. And then that does not stop the provisions of the Constitution from being enforced. And the question would be, did they resign? What is the evidence of resignation? There's electronic evidence versus membership evidence. Electronic evidence is acceptable now under Section 84 of the Evidence Act. We've seen people wrapped in colors for another party, flags and insignia for another party, singing popular songs in deference to another party. Is that sufficient evidence of change of membership? That's
okay. Does this also? Sorry to interrupt you, Doc. But then there were also those that have the conversations that these lawmakers at the time, while the speaker was there, read in his position as speaker, read on the floor of the House the resignation of the lawmakers and all that presented their letters on the floor of the House, declaring that they are no more members of the PDP and now members of the APC. And for the PDP at the national level at the time, speaking with the spokesperson of the party at the national level, he had said that alone, from the angle of the PDP, was enough for them to go to court because they saw a speaker who was making such statements in his capacity as speaker and receiving the letters of the members who were saying they wanted to join another political party. Is that enough to add to say, well, this is evidence to show that they are no longer members of that party?
Yeah, well, that's very strong. The reason why that is strong is because that would be a statement or a letter read on the floor of the House. It becomes part of the records of the House and ought to be reflected in the votes and proceedings of the House. And I want to believe that if that were correct and is correctly reflected at that resignation of court, it will mean that there is conclusive proof of resignation. And don't forget, whatever happens in the House happens in a public place. And whatever happens in a public place forms part of public records. And whatever is public record enjoys proof of regularity. In other words, it is assumed to be regular until you prove that it is irregular. So if a member gets up on the floor, which is the traditional way for members to resign, I resign my membership of Party X and I have now moved to Party Z, and it is recorded on the floor of the House, there can be no better evidence of resignation. I don't have this fact. I have never seen the votes and proceedings of that House of Assembly. But if they do exist, then that will be, in law and in fact, evidence of resignation of a member from one party to another, said on the floor of the House in a public place and recorded in the public archives, and to which extent anybody can get a certified true copy if you were to apply to the House in a normal order.
Okay.
So that's about the evidence required.
One more question before we go to the phone lines. This one is one that's been on the lips of a lot of Nigerians. You've talked about courts of competent jurisdiction and courts that are not of competent jurisdiction giving out orders that they shouldn't give on matters that they know very well that they have no jurisdiction over. Why does the court do this? We've seen countless times. That's number one. Number two, political matters that come before the courts that need to be attended to swiftly because it might affect governance and the government structure, if not swiftly looked into, seem to drag a very long time in this country. And this is an example of one of them. Some might even point to the situation in Edo State, your state, as another example where these matters would have been addressed early enough and done with, but it doesn't seem to be the case. Is there a reason why these things happen within the judiciary?
Well, the thing is, you have to understand that the judiciary is part of the Nigerian society, and it's also been affected by the general decline in the quality of our institutions. However, every court has jurisdiction to determine whether it has jurisdiction. You cannot say I'm a judge. I cannot tell whether I have jurisdiction or not. The proper thing to do, where the superior courts have already decided this matter, have laid a marker on it, it's as notorious as pure water sachets on the street. There is no reason why a judge should proceed to assume jurisdiction where he does not have jurisdiction. Now, if he does that, again, lays down Supreme Court decisions, in my view, that should be a question to consider about whether the conduct of the judge has fallen short of the standard required, and for which the judge should be referred to the judiciary body known as the National Judicial Council, which is in charge of discipline of discipline in terms of hiring judges. Now, the other point is you also have to be careful so that you do not intimidate judges in such a way that they no longer have the autonomy to decide whether or not they have jurisdiction, merely because a superior court had reached a decision of that nature, but with facts not similar and in different circumstances. So a prudent judge must be able to distinguish between what constitutes jurisdiction and distinguish that from what may have happened in a matter decided by the Supreme Court. But in the absence of a reasonable distinction, and then dabbling into a matter in which the Supreme Court said several times that when this happens, a particular court should have jurisdiction, and when this does not happen, a particular court should not have jurisdiction. I think it may be stiffer penalty may help to whip them online. Otherwise, sometimes the law is crystal clear on this matter, and there's no reason, to dance what I would like to call judicial skelewu on matters where you don't require such a dance at all.
All right.
And plunge society into confusion.
All right. We'll open the phone lines. There's also the issue of interpretation. That's also a problem because one case, one judgment comes, multiple interpretations, and we begin to see tendencies of certain lawyers interpreting it to favor their clients. And then the layman looks at it. This is written in black and white. What should happen? We'll come to that, but let's take a few calls first. And we'll start with Justice from Umudioga. Please, let's go straight to the discussion. If you have a question, straight to your question. If it's a contribution, keep it short and straight to the point. Justice, good morning.
Yes, my friend Andrew, good morning.
All right, go ahead.
Yes, on the question you asked, if the judiciary is part of the problem and challenges we are having in Nigeria, I would say yes, to some extent. The reason being that some judges allegedly have sympathy for one politician or the other. Some judges have sympathy for one political party or the other. This sympathy they have for these political parties and politicians, in part on their work, in part on their profession. And because of this sympathy they have, they give judgments that will generate reactions. So this is part of the problem we are having. And Andrew, secondly, you cannot tell me that all judges in Nigeria have the level of understanding and knowledge and intelligence. There are judges that do not have the proper understanding and interpretation of the law, unlike the other set of people. So these people that do not have this level of understanding contribute part of the problem we are having. The truth be told, judiciary is part of the problem we're having.
All right, Justice.
Just like the case of the judgment that was given yesterday in the River State political crisis. And we come to social media, you will see interpretation here and there. The people of Sim will interpret the way it suits them. The people of Wiko will interpret the way it suits them. There needs to be proper understanding. Let's know what the law says. For them, most of the judges do. We not do this thing for us.
All right, Justice. Thank you. Thank you very much. If you have been following the conversation, you must have heard my guest give out his opinion, and I think his opinion carries some weight because he's not just a legal practitioner, but a son for that matter. So with the wealth of experience, he should be able to give his own piece on what the situation is. Muriel from Africa, good morning.
Hi, Femi, good morning.
You're welcome.
Thank you. This is your Krika woman. Look, Femi, I've said it before and I'll say it again. If democracy collapses in this state, Femi, I think the lawyers, our judges, past and present, should be held responsible. Now, there is always this issue of cause and effect. In a country like the U.S., that the laws are clear. You will tell me that a lawmaker will defect, and the laws are there that when you defect, you automatically lose your seat, go and recontest in the next party, that you're defecting to. And our lawmakers know these things. Our judges, they know these things. And yet, they will begin to try to manipulate the system. What is happening is so wrong, and River State is going to serve as a litmus test. The whole world is watching. People are watching. A judge will know that this matter is presiding over does not fall within his jurisdiction. He will still honestly.
All right.
Now go back to the former status quo. The lawmakers have lost their seats. They can no longer sit. So we'll wait now for the proper judgment to come out. So there's no cause for alarm. Let's watch and see what the Supreme Court will do, whether they will turn around this country for the sake of these lawmakers. We're watching.
All right,
Thank you,
Stanley
Jim.
from Elele, good morning.
Yeah, Ifemi, good morning.
All right.
Ifemi, I want to appreciate your guests in the studio for throwing more light on the matter going on in Rivers State. Unlike what the Attorney General of Rivers State, Ugo Chinyere, has been saying.
Ugo Chinyere is not the Attorney General of Rivers State, please.
Huh?
Ugo Chinyere, no, he is not. He's a federal lawmaker. Ikenga Ugo Chinyere.
Which lawmaker?
Ikenga Ugo Chinyere is not the Attorney General of Rivers State.
He is. To me, he is the Attorney General of Rivers State because he has been peddling falsehood. He has been deceiving himself, not Rivers people. How will he come out to say after the judgment of yesterday that the 26 lawmakers remain sacked? By who? Even when the appeal court said...
Stanley, let's be fair and respect what he said. He said the matter yesterday, the judgment clarified the issue of jurisdiction. That was what he said.
You hear me? Can you hear me?
Yes.
Was it not the lower court that declared the Okojombo speaker and restrained Martin Amewule and the other members from sitting? Which other court? The Federal High Court that gave judgment in this matter before now is the court that the judge in Abuja gave verdict in favor of Martin and his colleagues. Which other high court? That's the reason why I'm telling you that I enjoyed what your guest is saying.
And my guest has put everything in proper perspective. Stanley, thank you. We get your point. And it's clear, but what I'm trying to correct you in, Ugo Chinyere did not say anything that is also wrong. He said the judgment clarified the issue of jurisdiction. And my guest also pointed in that direction. And clearly it did that. Let's hear from Alfred and then we come back to my guest to wrap up. Alfred Nemoha, quickly, let's hear you.
Andrew, thank you so much. Andrew, it's so unfortunate that you try to correct some persons of their wrong impressions and they will see continue with it and you didn't cut them off. And they are misleading Rivers State.
Alfred, you don't have time. You're wasting you have less than 2 minutes now.
Please, the person that just called should be guided in his utterances. And then, Andrew, I want to respond to your question that you asked earlier, that if the judges or the court is not one of the problem of Nigeria. I think it is. Recall that at the beginning of this matter, that Martin Amewule went to court, and one of their prayer is that status quo be remained, and that is to say that they be as he be as the Speaker of Rivers State Assembly, and the court said no. So if the court today will bring back Martin Amewule today, and then the court didn't still deem it fit to bring back status quo as it was, and the court is telling us today that the lower court don't have jurisdiction to hear the matter, and then same court which know the essence of crisis in Rivers State and know all that has happened in Rivers State didn't visit the matter that was even brought to court, which is the matter of defection. So now, what are they really telling Rivers people? Did they defect? That is the question. Tell us if these people defected or not. So this matter, will I know if they have
all right, Alfred.
Defected? Everybody would have rested on this case.
Thank you, Alfred. Doc, several of the callers with their opinions. We have less than 2 minutes to get a response from you. But then one of the callers asked a very pertinent question I would like you to conclude with. The Constitution is clear on what should happen when a lawmaker defects. Now, when a lawmaker defects, should they obey the provisions of the Constitution first before going to court to sort out anything? Because in the case we see, aside just these lawmakers, we have situations where what the Constitution spelt out as a consequence for this action is stated, but we do not have politicians follow. Instead, we go to court and get orders and get all the other things and then begin to act on those orders and not what was stated in the Constitution. What should it be?
Well, the Constitution is a guiding document. It spells out clearly what everybody's duty is. And under the Constitution, Section 109 makes it imperative for the Speaker at at the time of the crisis to make the pronouncement. Because really, if the speaker is fair and is not muddled up in partisan politics, when a member resigns on the floor of the House, it means that invariably his seat is declared vacant. The speaker will need to make that pronouncement, declaring the seat vacant and inviting INEC to conduct a by-election in place of that member who has just resigned. On the basis that the member resigned without a reasonable cause as prescribed by the Constitution on the floor of the House. The Constitution is very clear. When there is a division in your party and not a division in your village or in your state, the division must be national across Nigeria. Everyone will know there will be a parallel drawn to the extent that the whole world knows that there is a division in the party.
All right, Dr. West. Unfortunately, we have to conclude here. We'll definitely have you again because we know this is still continuing to unfold. But thank you for your time so far. Good morning.
Thank you very much. I appreciate it.
The House of His Presence is 20.